Welcome to the channel. Nicholas Sandmann's defamation case against the Washington Post was dismissed. And one of my favorite YouTubers, Viva Frei, did some great videos about the case and what's going on. But I'm going to tell you something. His analysis was wrong. Hey, my name is Nate and welcome to the channel. I'm a lawyer turned YouTuber and I make vlogs, reactions, and some legal videos. If you want to learn more about US law, consider subscribing to the channel. Now, I watch a lot of YouTube. I love YouTube. And I also love watching other lawyers on YouTube. You know, it's starting to get plentiful now. Now, my man Viva Frei is one of my favorites. He's a Montreal litigator. He's a YouTuber. And his channel is like fantastic. Now, he's made about 5 videos about this whole Nicholas Sandmann defamation case. And I'm going to link that playlist in the description. Now, my video is a response to his videos. I want to just go back. First, I was planning to do a review of this Nicholas Sandmann thing, but I really thought it was just an open and shut case. Now, for those of you who don't know, Nicholas Sandmann was the young man with the MAGA hat, and he was suing the Washington Post for defamation and libel. Now, in the United States, it is extremely, and I mean extremely difficult to sue and win, to sue a newspaper or a media organization for libel or for defamation. It is just almost impossible. It can happen, but it is very, very unlikely. So when I saw this lawsuit, I thought it was a loser. And when the Washington Post, just like, you know, the other news organizations, when they filed for the motion to dismiss, I thought, well, yeah, this is a no-brainer. This is going to be dismissed based on how the law is and how protective it is of news media organizations. But Viva thought the motion to dismiss would be denied. Now, I watched all his videos on the topic, and he started going down this road of it being unfair, saying things like, you know, Nicholas should have had his day in court, the judge was wrong. Now, these are all opinions, which is fine, but his reasoning was horribly flawed. Now, it may be because he practices in Canada and not in the US, and so I understand, you know, someone from that perspective may not understand the legal technicalities here in the United States. So I'm going to review his video and tell you where I think he went wrong. Now, before we get into all that, again, consider subscribing to the channel. Now, I need you to understand some very simple legal concepts before we get into understanding why I believe his reasoning for his conclusions are wrong. This case dealt with the motion to dismiss for failure to state a claim. Now, this is a very popular motion. This is what the Washington Post used to get this case dismissed. Now, I have dealt with many motions to dismiss, winning some and losing some, and this is generally the way it works. A plaintiff is going to file their complaint. Now, this could be a plaintiff or even a prosecutor. And in that complaint, they must make out sufficient allegations so they can recover. I know that sounds a little legalese, so let me just break it down. Let's say someone's arrested for speeding, and the law states anyone driving 20 miles an hour over the speed limit has committed reckless speeding. So here we know that we need someone driving. They have to be driving 20 miles over the speed limit. And if they do those two things, they've committed reckless driving. The prosecutor, in this case, is going to write out a complaint. The complaint is going to read, the defendant was driving down Main Street and was pulled over by the officer. The officer arrested the defendant and charged him with reckless speeding. Should this complaint be dismissed? And if so, why? In a motion to dismiss for failure to state a claim, the first thing we'll do is we're going to take all the allegations in the complaint as true. So what allegations do we have in this particular complaint? The first allegation is that the defendant was driving, and the second one is that he was just arrested. There's nothing else in this complaint that really tells you anything. The defendant was driving down Main Street. I'm accepting that as true. He was pulled over by the officer. I'm accepting that as true. The officer arrested the defendant. I'm assuming that is true. And charged him with reckless speeding. I'm assuming that fact is true. So all these allegations and all these facts within the complaint, I'm assuming to be true. Because I'm assuming them to be true, does this mean the prosecutor has made sufficient allegations to charge this person with reckless speeding? Well, to be charged with reckless speeding, the complaint would have had to show that the defendant was driving 20 miles an hour over the speed limit. The complaint didn't tell you how much the speed limit was, right? You don't know. It didn't even tell you what the defendant's speed was. You just don't know. So as a matter of law, all the allegations in the complaint are not enough to sustain the cause of action. This is typically how a motion to dismiss for failure to state a claim is decided. We are talking about all the allegations of the complaint being true, and even if they are true, could this person win? In any lawsuit, you make allegations to and prove those allegations with evidence. That could be witness statements, testimony, but you're using that evidence to prove your allegations to be true. But at this stage, the stage of motion to dismiss for failure to state a claim, I'm stipulating for this particular piece that all your allegations are true. And even if they are true, you are not going to win. As a matter of law, you haven't sufficiently given us enough where you could win, even if all your allegations are true. And this is the point that Viva has missed. Now, he's been crying outrage about how the plaintiff was not able to prove through evidence his allegations. But that doesn't matter for the purpose of the motion to dismiss. As the judge, I don't need for you to show me any evidence. I'm assuming all your allegations are true. The evidence that you're going to present are going to show me why your allegations are true or try to prove them to be true. But I don't need that because I'm already assuming they are true. Now, why do we do these in a motion to dismiss, and why do it so early within the case? That's because the court doesn't want to waste time. If you're alleging something that's happened and you're alleging that you can recover under law, and then you put together a complaint and that complaint doesn't sufficiently allege all the elements that's necessary for you to win, then your case should be dismissed. It is an improperly pleaded allegation. And the court doesn't want to have a trial, induce evidence, and wait till the end, 2 or 3 months or even years down the line at the end and say, well, your original complaint didn't even plead all the elements, so we're going to dismiss it because of that. No, you can do that up front. We're not going to go through this whole video. I know you're probably saying, thank God. But we're going to go through, I think, maybe like 10 minutes of this video, and you'll see where we start having problems. So this is, it's a really, really fun video. I'm going to say, don't forget to subscribe to this guy's channel. He's really, really good.
Basically, this motion to dismiss seeks the premature dismissal before any hearing on the merits, before any witnesses have been heard. It seeks the dismissal of the suit and the preclusion of the plaintiff from ever suing on the same or similar basis again.
Why? Because we're saying, if this is what you have, and we're assuming all of it to be true, we don't need the evidence. We don't need, your evidence is to prove these allegations true. We're saying they're all true. So if they're true, is it enough to state a cause of action? The court says no.
Chances of that happening? I will eat my torn Tommy John underwear. How's that?
No. Yeah, I saw this before. I remember. You had to eat it. Yeah. But he didn't eat it, but whatever. Hey, listen, this is a really good channel.
Federal
I love
Judge
it.
William
I do love it.
O. Bertelsmann actually granted Washington Post's motion to dismiss of Nicholas Sandmann's defamation lawsuit.
He did.
Obviously, I have to do a follow-up breakdown of this judgment, given the fact that a while back I did a breakdown of the Washington Post's motion to dismiss, and I did not think it had any reasonable chance of success at the preliminary stage of a dismissal before evidence was made.
And now see, this is, I think that statement that he just said, dismissal before evidence was made, I think that's the key. He doesn't understand. You would ask the plaintiff to bring in evidence to prove their allegations. At a motion to dismiss, I'm assuming your allegations are true. So there's no need to bring in evidence. You're going to bring in evidence to prove something is true that I'm already assuming it's true for the purposes of the motion to dismiss? That makes no sense. That's a waste of time. And that's the piece that I think he's missing here.
Now, obviously, my initial prediction was wrong, with the caveat that Sandmann's attorneys are going to appeal the dismissal of the suit, so we'll see what happens at the Court of Appeal, and my analysis...
That's true. You never know what's going to happen. They could reverse this opinion on some technical grounds, but it's going to, it's that's even, I'm not going to say eat my shorts, but that's like playing a lottery. It's possible to happen, but it's unlikely.
Analysis of Judge Bertelsmann's granting of the Washington Post dismissal of suit is not going to be an attempt to sort of correct or justify my initial prediction. I rewatched my original video on the subject, and I pretty much stand by everything I said in that video because I believe it to be true, and I believe it still to be true. And reading Judge Bertelsmann's decision, inasmuch as the Washington Post's motion to dismiss read like a defense, Judge Bertelsmann's granting of the Washington Post's motion to dismiss reads like a judgment on the merits.
Again, and this is where it does read like a judgment on the merits. The reason why is he's assuming all the allegations are true. I don't need a trial for you to prove to me they're true if I'm assuming them to be true. And if it's not enough to prove your cause of action, then we're not going forward. You have to submit sufficient allegations. Remember the car example? If you're telling me someone has committed reckless speeding, that means they're going more than 20 miles over the speed limit, and you haven't told me what the speed limit was or how fast the driver was going. You haven't made sufficient allegations. I don't know what you're talking about. You're wasting the court's time.
Bearing in mind that this is a long process and it's not the end of the game right now, but again, it's not a question of being right or wrong. I don't mind being wrong. I've been wrong in the past and I'll be wrong again in the future. The only thing...
Yeah, and I do want to say this too. This guy's a brilliant attorney. And my objections to his reasoning are minor at best. It's minor technical pieces of it. So don't think this is some type of attack video against this guy. I watch this guy. I'm subscribed to this guy. I love this guy's content. So, you know, I don't want this to be like an attack video against. No. We just have one small disagreement, and I think he just doesn't realize. You know, he's continuing to make videos about this, and I think he doesn't realize where his mistake is, and that's why I'm doing this video.
Thing is that you want to make sure that you have a reasonably educated opinion at the time, and like I always say, once you leave something in the hands of a judge, you can never predict the outcome. All right.
That is so true.
We do not once again need to do a detailed breakdown of the timeline of events, the facts. I take for granted that everyone watching this video already knows the facts. If you do not already know the facts, go watch my 2 previous videos on the subject, watch other people's videos on the subject to get an understanding of the facts. At this point, I would feel comfortable in saying that if someone does not know what is going on in this situation, they have in fact been living under a rock in a cave with no electricity and no neighbors to relate to them what is going on in the outside world. The decision. At page 4 of the decision, the judge sets out what are going to be the parameters of his judgment. The court must now determine whether Sandmann's allegations state a viable claim for relief. These are purely questions of law that bear no relation to the degree of public interest in the underlying events or the political motivations that some have attributed to them. And this is an important statement setting out the framework of the judgment on the Washington Post's motion to dismiss. The judge is saying that these are pure matters of law. Hence, the judge is in a position to adjudicate on them at the early stages of a motion to dismiss before evidence has in fact been adduced.
Correct. He's 100% correct.
So the judge looks at the statement of claim, the judge looks at the motion to dismiss, and the judge says whether or not, in law, as a pure question of law, there is a viable claim to be submitted to a trial by jury.
Correct. Remember, with the 20 miles an hour, if there's no allegations that the person is actually driving 20 miles an hour over the speed limit, then we can't submit it to a jury, because let's say the jury was to find him guilty. But guilty of what? There's no allegation that he was actually violating the law, going 25 miles an hour over the speed limit. So this is 100% correct what he's saying.
Whether or not the judgment in fact purely adjudicates on matters of law is something that we'll discuss, but that is the framework within which the judge is supposed to render his decision. At page 5, the judge writes as follows. The court need not, however, quote, accept the plaintiff's legal conclusions or unwarranted factual inferences as true.
This is where he goes off the rails. Now, he reads, let me let him finish reading.
State a valid claim, a complaint must contain direct or inferential allegations respecting all the material elements under some viable legal theory. Accordingly, in ruling on the Post's motion, the court may consider the 7 articles, the tweets, and the 2 YouTube videos because these materials are either referenced in or attached to the complaint, and Sandmann relies on them in support of his defamation claim. The court excludes all of the materials attached to the parties' briefs.
Because they're not in the complaint. The piece that he read from, he skipped a paragraph. Now, here's the piece that Viva didn't read, the piece that he skipped. It says, A, Rule 12b-6. On a motion to dismiss under the Federal Rules of Evidence, the court must construe the complaint in light most favorable to the non-moving party. That's Mr. Sandmann. Accept the well-pled factual allegations as true, and determine whether the moving party is entitled to judgment as a matter of law. So here it sets out the standard at which the court is going to be looking at the information. Again, well-pled factual allegations, accepting that is true. We're going to give the non-moving party, which is the plaintiff, all the favorable inferences, and then we'll determine whether whether a dismissal is warranted as a matter of law. So remember our example of the car. If you don't allege the person is actually driving 20 miles an hour over the speed limit, then as a matter of law, that defendant cannot be prosecuted based on this complaint. The complaint is insufficient.
And so what the judge is saying right now is that he is going to base his decision on the Washington Post's motion to dismiss solely on the articles, the tweets, and the YouTube videos.
No, solely on the complaint. Solely on the complaint and the things that complaint points to as support. So whatever the allegations are in the complaint and the support that they're using to show the complaint to be true, we're using all of that to determine whether he sufficiently pled a cause of action that he can recover from.
that are referenced in Nicholas Sandmann's statement of claim. There's not going to be any testimonial evidence from Nicholas Sandmann, from Nathan Phillips, from Washington Post journalists. The judge is just going to rely on the 7 articles, the 2 tweets, and the YouTube videos in order to determine whether or not Nicholas Sandmann has made sufficient allegations to justify his claim in law.
Now, why don't we need all that stuff that he asked about? Why don't we need the witnesses? Why don't we need the Washington Post? Why? Because we're assuming everything in Nicholas Sandmann's complaint is true.
At page 6, the judge goes on to state the criteria for establishing defamation under Kentucky law. In Kentucky, a cognizable claim for defamation requires A, a false and defamatory statement concerning another. B, an unprivileged publication to a third party. C, fault amounting at least to negligence on the part of the publisher. And D, either actionability of the statement irrespective of special harm or the existence of special harm caused by the publication. Now, ultimately, the judge is going to grant the Washington Post's motion to dismiss on the basis that the Washington Post's articles are not about Nicholas Sandmann, in that they don't specifically identify him, they don't name him by name, at least in some of the articles, and they're referring to a group of people, not specifically Sandmann, such that these statements are not defamatory about Sandmann per se because they do not identify Sandmann. Another basis for granting the Washington Post motion to dismiss are going to be that these statements in and of themselves are not defamatory because they are either opinion, susceptible of interpretation, and are not factually incorrect statements about Nicholas Sandmann. And at the end of the judgment, there's a table indicating all of these statements and the reason for which the judge concluded that they were not defamatory.
Now, this is important. This table that you're seeing on the screen now is important because the judge is now saying each of the statements in the allegation we're accepting to be true. But now the judge is putting as a matter of law why they can't be used to support a defamation claim. Now he's going to go through all of these reasons why. But again, understand why we don't need evidence, why we don't need the witnesses. It's because the judge is accepting all this to be true and saying, well, even if the statement is true, even if the statement says what you say it is, as a matter of law, an opinion can't be the basis for a defamation suit.
And then at page 27, the judge distinguishes other articles which in fact name Nicholas Sandmann, all within the context of the same allegedly defamatory events. So you have some articles not specifically naming Nicholas Sandmann, other articles specifically naming Nicholas Sandmann, and then the argument is going to be, well, the first ones which didn't specifically name him are not defamatory because they don't specifically name him, while the other ones are not defamatory even though they do specifically name him.
Exactly.
This is arguably one entire global context where even though Nicholas...
All right, let me explain this. The ones that don't specifically name Nicholas Sandmann, he cannot support a claim of defamation because to have a claim of defamation, those statements would have to specifically name him and not a group. So all those statements that don't specifically name him are out. The ones that do name him, so now you don't have that same issue. So you have a set that are gone. Remember that whole list that he had? That set is gone. Now you have a set of ones that do name him. The ones that do name him are no good because they're based on opinion. Not because it doesn't particularly name him, but because they're based on opinion, and if they're opinions, they can't support a defamation cause. So you can have a case like this where you have certain statements that are thrown out because of one reason, certain statements that are thrown out because of another reason. This is I don't know what to say.
And so that is basically the gist of the judgment. Had this judgment been drafted after all the evidence had been adduced, that would be one thing. The fact that it...
But now listen to that. If the judgment had been drafted after all the evidence had been adduced, this is the big hole. This is the bomb. If you're asking if the allegations are sufficient to support a claim for defamation, where the plaintiff can actually win if all the allegations are meant to be true, then the judge assumes that all your allegations are true and gives you all reasonable inferences. Then why would I need any evidence? Because the evidence you're going to provide, presumably, is to prove that your allegations are true. So per se, I'm already presuming they're true anyway. So I don't need your testimony. I don't need your evidence. I don't need any of that because I'm presuming your allegations are true. This is what Viva doesn't understand. And if I'm presuming your allegations are true, then you're in the best possible position because only thing you have to do is meet the very, very minimum requirement of just stating a claim that you can actually recover for as a matter of law. Here, Nicholas Sandmann did not state a claim that he could recover for. I'm sorry. That's why it was dismissed.
It is a judge at a preliminary stage on a motion to dismiss without having heard any testimony, without any evidence having actually been deduced, seems grossly premature.
And I think that's the nail on the head. Ah! Why do I need evidence for you to prove something to me that I'm already assuming to be true? There is no need for it. It's almost like inconceivable. Like, why would you want to waste the court's time to then show me all this evidence and show me everything, and I can say at the beginning, well, hey, listen, you didn't even plead enough. You didn't even tell me your complaint wasn't sufficient enough to even if you've won, to recover. That's what this motion to dismiss is saying. I'm going to assume that everything you're saying is true in your complaint. All right. So why do I need to hear your witnesses? You're bringing those witnesses and that evidence to prove to me that these allegations that you put in your complaint are true, right? So if I just assume that they're true, I don't need these witnesses, right? No, for what reason? I'm assuming they're true. I don't need this. I don't need that. I'm assuming all your allegations are true. I'm assuming all your evidence is going to say to what it says. I'm assuming all of that, or give you all favorable inferences. And doing all that for Nicholas Sandmann, as a matter of law, his complaint was insufficient to support the cause of action of defamation, period, under U.S. law.
Either way, it is not a question of me trying to save face or justify a prediction that did not come to fruition. It is just a question of understanding the facts so that you can come to a reasonable assessment, even if you happen to be wrong.
We have a fundamental disagreement about now, and I think he just doesn't understand why U.S. law allows for this trigger. Maybe they don't do this in Montreal. Maybe they go through the whole trial, and at the end of the trial, like for my car going over 20 miles an hour over the speed limit, maybe they go through the whole trial and be like, well, hey, at the beginning, you never said that he was actually going 20 miles an hour over the speed limit. Oh, well, we never said that. So, you got a 4-month trial, and at the end of the trial, you got to dismiss the trial because there's no evidence or no allegation that he was actually speeding. That is why we have these motions to dismiss. The court doesn't want to waste time. Now, I do want to say, this guy is a great internet personality. He's a great lawyer. I have no qualms with him. I watch his stuff. Please do not believe that this is any type of attack video against this man. He is fantastic. I watch his stuff. I'm going to continue to watch his stuff. I watch his live streams. This is not that type of video. Hey, my name is Nate. Don't forget to click. I don't know where I'm going to click. Something's going to pop up on your screen. Click that for some more great content. And consider subscribing to the channel. I'll speak to you next time. Peace.